It is for episode number 1.
May I please your lordship? Lordship,
Number 3.
The learned amicus curiae
Yes, Lordship.
for the appellant
Amidst suspect.
is found absent today on call. MSSH Bora, learned traditional public prosecutor. For the respondent number 1, state of Assam, is in attendance. Offense is under 302. Okay.
Lordship. Since Lordship
As
answer
we
has been
received.
received, Lordship, paper.
As the
will be read.
records of the learned trial court have been received, comma, the registry to prepare the paper book. Leave the
Okay.
case after court.
Okay.
Item 4.
Lordship, in this case, we have filed our objection. The service is complete, but Mr. A. Ahmed's name is not shown in the cause list, my lord. He was appointed as an amicus on 21 to 2024.
21 to
2024, my lord.
then let us list it after a week or two.
Lordship, his name is not shown.
MS N Hassan.
And Hassan.
Okay. Hired MS N Hassan, learned counsel for the appellant, and MS B Bhuyan, learned senior counsel and additional public prosecutor, assisted by MS and B B Bora, learned counsel for the respondent number 1, state of Assam. Post of on 21 to 2024. Comma, this court has appointed Mr. A. Ahmed as amicus curiae to appear on behalf of the respondent number 2. Full stop. MS Bhuyan has submitted that an objection to the interlocutory application. The application under section 89 CFC has already been filed.
Next.
The respondent number 2 may file its her his or stroke his stroke her written objection in the meantime, comma, if so applies.
Item 5.
may I please your lordship? One day delay, my lord.
One day delay.
Delay one day. Did you condone?
Low also. Hard. Learned counsel for the applicant's appellants. On MS. Friends. BP, huh? Only one day.
Register approval is not number of.
Judgment
These are the topic.
dated 16/12/2023, an order of sentence dated 20/12/2023, sessions case number 125 of 2018. Session Judge, instead of special court, Session Judge Kasar S. Silsor, convicted under sections 302/34, IPC, undergo life imprisonment and to pay a fine of 10,000 each. Life imprisonment each and 10,000 each. In default of payment of fine, to undergo simple imprisonment for another 3 months. Okay. So region connected into the paragraph 3, 4, 3 and 4. Issuance of notice not required, substantial justice. See, leave to oblige.
For pronouncement of judgment, item number 5.
Writ petition is dismissed.
Okay.
May it please your lordship. Lordship, I beg to mention a listing of two criminal petitions. Both are arising from the same nature of negotiable instrument act. Lordship, the matter is fixed before the learned trial court in Hailakandi on 5/6. Lordship, if Lordship may fix it for hearing on first week of May.
Hearing,
Yes, Lordship.
of which year
2020.
any stay order is operating.
No, Lordship. Stay is not there, Lordship.
Okay, let us put it for orders next week.
Much of. Lordship, one more. Lordship, it's a criminal petition, Lordship. We are the informant and opposite party in this. The petitioner has challenged the FIR, Lordship. So Lordship, may please to fix it on the first week of May.
No, is there any returnable date?
No, Lordship. We are the opposite party in this matter, Lordship.
Let it come. It will come as per usual course.
Much obliged.
Motion item number 1.
May it please your lordship. Well, in this case, my lord, it is
Yes.
yes, my lord. This criminal petition is filed, my lord, against the order, my lord. This, my lord. 21/12/2023, Annexure I. Annexure I, and
Annexure I is at which page?
yes, my lord.
Lordship, page 42,
Yes, 42, my lord.
Benting order dated 21/12.
And another, my lord, there is, my lord, Annexure F, my lord. Order 23/11/2020.
Mm-hmm.
This Annexure F, my lord.
Annexure F page,
PS, my lord, PS 28, my lord.
page 28.
Before that, my lord.
Okay, cognizance was taken
Yes, my lord. This PS
on 21/23/11/2020.
2020.
Yes.
Okay,
Basically, my lord, this day
and what is, let us see the order next, I,
I is my
page 42.
yes, when we came to know there is a proceeding, my lord, we file a petition and page 42, my lord. Page 43, my lord, there. For the FIR was as well as the material available on case record and CD, it is saying that allegation against the accused person is lucky search and physical assault upon women, and outraging the majesty of women. These are the, my lord, the as per the code below, these are the allegation, my lord, against the accused person, my lord. And finally, my lord, it is 45. 45 kilo, 45 kilo. এই মার্ক করা আছে আগরটো
What is the allegation about in the FIR?
Yes, madam. There's two FIR, madam. One is filed by.
No, we are concerned with which
Yes, ma'am.
FIR, which FIR?
Both, it was, search sheet was filed on the basis of the, first, next A, my lord. It was filed by Mala Madan. And there is
Mala Madan.
Mala Madan.
So search sheet was filed
On
in
the-
connection with that case.
Yes, madam.
Where is that FIR?
FIR is
Page
page
15.
15, madam.
Page
15, madam.
15.
LCR also available, my lord.
No, what is that village road? Is it a public road or it belongs to you?
It belongs to the army area, madam. Army area, madam. And that,
Where from you are saying it is army area?
my lord, it is, Sarsit also speaks, my lord.
Hmm?
Sarsit also speaks, my lord.
Let us see.
Page 25 is the charge.
My lord, the page 26, 25, my lord, the Sarsit in vernacular, my lord.
What is chromic number? Do we saw?
What is, my lord? It is, my lord, there is, my lord, one meeting was held. my
হ্যাঁ,
lord. Yes, my lord.
উক্ত সভাখন
With the civilian and the, civilian.
ক্ৰমিক নম্বৰ 2ৰ 6 নম্বৰত ঘটনাস্থলীৰ সূত্ৰপাত হোৱা পত্তিৰ বিষয়ে উল্লেখ কৰা আছে।
Yes,
Road from civil area behind Road from civil area behind the civilian. No, come to page 26,
Page 26, yes, my lord.
the English part.
Yes, my lord.
Please read.
The road from civil area behind a civilian defense employer. So residents to the civilian basti, so and so will be allowed to be used by the civilians till such time and alternate road is made by the civil government. Civil government after carrying out proper survey area, but checking will be continued as it to the port. The road from the so and so to check post will remain closed until decision is received.
So from this part, it appears that there are two roads.
Yes, ma'am.
One is the road from civil area behind the civilian defense employees residence to the civilian basti.
Yes, ma'am.
And other one is road from Tusar Chakros to check post. Right.
Yes, ma'am.
Yes,
The second road is Tusar Chakro to check post will remain closed.
yes.
So
There's,
occurrence took place pertaining to which road?
Hmm.
First road or second road?
কিন্তু বৰ্তমানলৈকে উক্ত অঞ্চল কোনো যাতায়াতৰ
No, no, English part, from the English part.
Yes, ma'am.
there are two routes.
There are two roads.
Yes, ma'am.
Right?
Yes.
The road from Tusar Chakra to check post will remain closed
Yes, ma'am.
until decision is received from the higher headquarter of the army. So that appears to be closed.
Closed.
Yes.
And that was a decision taken on 21/11/2011.
Yes,
And there is another road, the
Yes.
road from civil area behind the civilian defense employees residence
Yes.
Yes.
to the civilian basti,
yes.
Patidoi Verala, which will be
Allowed.
allowed to be used by the civilian till such
Right.
time an alternate route is made by the civilian government or after carrying out proper survey of that area, but checking will continue
As,
as hithertofore.
yes.
So this road is made
for the-
open in a limited manner
Yes,
for the purpose of use by the civilians.
yes.
Right? Now, the dispute or the incident occurred in respect of which road? Firstly,
My lord, may I submit my lord one thing, my lord? Here.
no, my query,
My lord, in my lord, the search sheet, my lord, there is no specific indication is there, my lord. Only this,
so first tell me
Yes.
that it is related to first road or second road.
my lord, it is, I have not, in the such instruction, I have not such instruction, my lord.
See, if it is the second road, which is already closed,
Close.
if the civilian attempted to use the road, then definitely you have a very good case.
Yes, my lord.
If it is the first road,
Yes,
which is to be used by the civilians in a limited manner,
yes, ma'am.
then we have to go through the facts and
Yes, yes,
circumstances of
yes,
the case. Please tell me which road,
That I-
because search sheet from the search sheet, it appears that it is the first road.
Yes,
মোকৰ্দমাৰ তদন্তকালত উক্ত অঞ্চলটোৰ পৰা সেনা চাউনি হৈ অন্য ঠাইলৈ যোৱা একমাত্ৰ পথটি অন্য বিকল্প পথ নোহোৱালৈকে খোলা থাকিব যদিও তালাচী প্ৰক্ৰিয়া চলি থাকিব. It means perhaps the first road.
one, yes.
কিন্তু বৰ্তমানলৈকে উক্ত অঞ্চলৰ পৰা অন্য ঠাইলৈ যোৱাৰ বাবে যাতায়াতৰ উপযুক্ত পথ নোহোৱাকৈ সেনাৰ লোকে পথ নিৰ্মাণ কাৰ্যৰ বিৰোধিতা কৰিবলৈ যোৱাত what পথ নিৰ্মাণ কাৰ্য, which part?
Well, here,
Have you Are you clear on the facts?
Yes, yes, well, no, so far this road, road, I have not proper instruction, my lord, whether, which road, my lord,
But because your duty is to check.
yes. It is, my
Check
lord,
the
yes,
civilians.
my lord, but it is night time, my lord, the night time, my lord, 1 o'clock, 1 p. It
No,
was-
firstly, Mr.
Yes,
Mehdi,
yes,
let
yes,
us
yes,
clear on
yes,
the facts.
Yes, understand.
Then we'll go who is the aggressor, who is not the aggressor. We'll come to that. But if you read this, উক্ত অঞ্চলৰ পৰা সেনা চাউনি হৈ অন্য ঠাইলৈ যোৱা, do you have any sketch map kind of thing?
My lord, it is, LCR is there, my lord, LCR is
Oh,
there.
it is you to
Actually,
present the
no,
facts
No, I have
in
not.
a vivid manner.
Yes, I'll, my lord.
Have you identified them?
It is, for me, my lord, without this instruction, it is not possible, my lord. So, my lord, if lordship may fix another date, my lord. Our basic question is, my lord, this, whether.
Your question I can understand.
Yes, my lord. This,
But
without,
so far your plea regarding Armed Forces Special Powers Act, that is, I don't think
My
this
lord,
this is a case of Armed Forces Special Powers Act. Yes, it is. It might be a case of 197. But
197
don't
to,
invoke everywhere
yes,
Armed Forces Special Powers Act.
No, no.
Have you gone through Armed Forces Special Powers?
my lord, 197 too, my lord.
That is different thing.
Yes.
But don't invoke everywhere Armed Forces Special Powers Act.
Because, my lord, this,
Mr.
my lord, your lordship.
197 might be a reasonable ground to
Yes,
take.
yes, my lord.
But don't take Armed Forces Special
And
Powers Act
the-
everywhere.
Another thing is, my lord, when these cognizance is taken, my lord, there is no reasoning, my lord.
No.
This is just, my lord, this only
Let
fill
us,
the record, my lord, this is cognizance taken, my lord, and
Let us-
there is 2 FIR, my lord, 2 FIR. This is in a case record also, my lord.
Mr.
This-
Mehdi,
yes.
it is the Mala Modern FIR where the charge sheet has been submitted,
Yes, my lord.
right? Let us clear the facts.
Yes, my lord.
Don't bring the other FIR where no charge sheet has been submitted, no cognizance has been taken.
But it was in record, my lord.
That does not mean,
Yes, I understand. But facts is there, my lord.
Mr. Mehdi,
Yes, yes,
where no cognizance has been taken,
yes, my lord.
where no charge sheet has been submitted,
Understand, my lord.
why we should deliberate on it?
Yes, my lord. But
Right.
But because of facts,
The
my lord,
Mala Modern
something-
FIR
Yes,
has resulted into a charge sheet,
yes, my lord.
Yes.
right?
Yes, my lord.
Their cognizance was taken,
Yes.
right?
Yes.
Then thereafter, process was issued.
Yes.
So you are agreed by that.
Yes.
Then you file an application
Yes.
seeing that twofold submission
Yes, my lord.
from the order
Yes,
impugned,
Yes.
it reflects
yes,
that twofold submissions were made, that before cognizance to be taken,
yes, my lord.
sanction under 197(2) CRPC is required to be taken.
Yes,
Otherwise, magistrate is not authorized to take cognizance.
yes,
Second limb of submission was that we invoke Armed Forces Special Powers Act. Prima facie, this court's view is that you cannot invoke
Yes.
Armed Forces Special Powers Act everywhere
Mm.
in the blockage of a local
Yes,
local road.
I understand, my lord, but it was, my lord.
You are not in counter-insurgency operation.
My-
Yes, but there may be some substance
Yes, my lord.
in your first limb of submission, 197(2).
And
Right.
another thing is, my lord,
Now, for that purpose,
yes,
whether cognizance, the magistrate is to be restrained from taking cognizance.
yes, my lord.
For that purpose, we have to see whether the act alleged on the part of the army personnel was in discharge of the duties
yes,
Duty.
of their duties or in purported discharge of their duties,
Yes, ma'am.
right?
Yes, my lord.
Let us focus on the
Yes.
core issue.
Yes, my lord.
Don't go here and there, that there is second affair,
Yes, my lord.
right? Now, question is, if the road, right,
Yes,
where a civilian tried to stop you from the checking duty belongs to army personnel,
yes,
then you might have a right to stop them, right? So, if in the course of discharging such duties, if it is initially public duty or discharge of your duties, and in the course of execution of those discharge of duties, you have exceeded something,
Yes, ma'am.
right?
Yes, ma'am.
In that case also,
I
it
understand.
might come under 197,
Yes, ma'am. I
right?
understand.
Let us be clear on the facts.
Yes, ma'am.
It might come under if you exceed. Now here the allegation they have brought is 354,
Yeah, I understand.
which is
Yes.
otherwise
Yes, madam.
not,
Yes, madam.
do not fall under discharge of
Official.
Yes, madam.
official duty,
Yes, my lord.
right?
Yes, madam.
But still you might have a case if the initial power
Yes.
that you were discharging your official duty.
Yes, madam.
Right. Now, have you gone through? They have vividly,
I have not done.
ah,
I have not done.
then you have left it to the court.
No, my lord. Actually, it was my lord.
CR is received.
Yes, my lord. Only the Monday, when search sheet was filed, my lord, the last page, page 27, my lord.
Let us be clear
Yes, yes.
where the occurrence took place.
Yes.
What is the date of occurrence?
Date of
Date of
occurrence, my lord,
occurrence.
21/11/2011.
21,
11/2011.
2000,
11.
date of occurrence.
2020, but as per lordship's,
20.
yes, it was wrongly written
2020,
2011.
my lord,
It
it
should be
was,
20,
my lord, it
lordship.
was, my lord, below name, in, page 15, my lord. With due respect, this Azahar, my lord, first.
Lordship Ajahar 31/2020.
2020,
31,
Yes,
yes, and it was,
date of occurrence is 31/2020. But it has wrongly written in CS.
1, 2.
Yes,
FIR was lodged on 1, 2. FIR was lodged on 1, 2.
yes, the
if
date
I
of
dated
occurrence
date,
is
my lord,
31.
31, my lord.
31,
31, it was,
2020.
it was subsequently registered.
FIR was registered on 1, 2,
Yes. And-
right?
Yes, date of occurrence is.
No,
31.
there was a meeting on 21/11/2011.
Yes.
And according to that, this checking goes on. So 197. Service.
Sure, this one thing.
Do you have the Armed Forces Special Powers Act?
Yes, my lord.
Let us have.
It is. You can look.
Yes, MS Bora.
Lordship, other way also, Lordship, as per section 460, subsection E of CRPC, Lordship,
Two.
section 460, subsection E of CRPC. Lordship.
460.
Yes, Lordship. What does it say, Lordship? If any irregularities is caused in taking cognizance.
Subsection
Subsection E, Lordship,
460.
460 of CRPC, Lordship.
Hmm.
Subsection E. 460 irregularities which do not vitiate proceeding. Lordship. Main heading.
Yes.
If any magistrate not empowered by law to do any of the following things, namely subsection E, to take cognizance of an offense under clause A or clause B of the subsection 1 of section 190, erroneously in good faith does not, that thing is, his proceedings shall not be set aside merely on the ground of his not being so empowered.
But 197
Lordship,
stands on a different
Lordship.
plank.
On receiving complaints of citizens of police.
Perhaps it will not vitiate the entire proceeding, Lordship. As per 460 subsection E.
One 197(2).
Lordship.
Notice is served or not?
Notice served, my lord.
Huh?
Notice served, my lord. And as per my,
Neither educated nor, no.
track report, my lord, they receive, my lord.
Where is it?
Uh,
No, your track report will not do.
yes, my lord, but postal track report, my lord.
When did you send? Thirteen. 13.
And moreover, lordship, allegation against a former lordship is assault upon a woman and and lordship modesty, outraising modesty of women, the two allegations basically. So perhaps these two allegations does not fall under the ambit of discharging official duty, lordship.
Hmm.
So far as Armed Forces Special Power Act is concerned.
We are not into armed forces, but 97(2) is
Yes,
general.
yes.
We are not
Yes.
dealing with.
And my lord,
Have you given copy?
Armed Forces Act.
Armed forces.
yes, I have, my lord.
এটা তো আমি তো নোয়ার এটা তো কোর্টে গিয়ে হবে।
My lord, so far, my lord, the allegation.
Whether that two allegations will come within the ambit of discharging of official duty.
For that, there
That
is
is
a photograph, my lord. In record, my lord.
The photographs are secondary. evidence.
They produced, my lord. Produced by them, my lord. It is completely false allegation, my lord.
And lordship, kindly come to section 197, subsection 1, explanation. Lordship, kindly come to that. Yes, subsection 1, the explanation part. May I read, lordship? For the removal of doubts, it is hereby declared that no sanction shall be required in case of a public servant accused of any offense alleged to have been committed under section 166A, section 166B, and section 354. Here is the cognizance has been taken under section 354. So
That is, my lord, 197(1), my lord. The proviso is for 197(1), my lord, not for 2. Yes, yes, ma'am.
since Sarsit has been filed under section 354. Lordship.
But not really.
What is the law?
Otherwise, lordship, subsection,
Heard about the constitution by there is no Mata joke also.
Makazo Dole.
no,
I have nothing.
Mata joke.
Dole, my lord. Makazo Dole. In this regard, my lord, I have some written argument.
This code has already delivered his judgment in 2000.
lordship.
2021.
Code has already 1720.
Lordship.
And on the very same point, 18,
Lordship.
Supreme Court delivered it.
Not,
It executive. The result is that way.
not,
You recognize. If all
not,
recognize is hard,
yes,
so order of recognizing the person that rules of forward is nature of
yes,
exceeded
yes,
the limit and causes some offense. What is it?
yes,
And that's where. And that does not mean that complaint will be
Yes, madam.
paid.
Yes, madam.
yes,
So for the order of recognizing.
yes,
But
yes.
that,
What?
no,
Yes,
but till the time
yes,
the complaint will be at liberty to obtain
Yes,
big sanction.
yes, in the meantime.
But
yes, yes,
the law.
yes,
Up to the statement of the lady,
yes,
but case of occurrence,
yes,
case of occurrence. Is of the case according to appear just of the gate
yes, Lord,
of the army. Gate.
Lordship,
So they have a very,
yes,
and this army person is the. From the second,
Lordship,
and for this. Then, affects.
yes,
They just, right, so that they should be army.
enter the civilian, yes,
So that is, I make use of confidence.
might be, yes,
They may stop, otherwise the role
yes,
is inside the army.
and my lord happened at 1 p.m. my lord, at night my lord, day one my lord, to resist my lord. And the our application before learned CGM my lord, until my lord, the prosecution sanction is obtained my lord, that may be stated. That was our application before the same. The prosecution sanction my lord, it is I filed an written argument also my lord, next some judgment of the apex court my lord regarding my.
Matajur Dole.
Yes my lord, yes my lord.
Court has
Yes,
declared
yes.
thereafter, the Supreme Court on 17,
Yes, my lord.
we can do one thing, we should dispose of this public interest status that they have said in service something
Service is complete my lord.
that put it, here,
My lord,
Lordship,
my lord,
dispose it of,
my lord, next,
here.
I'm out of station, my lord. Only my lord is, after, in the meantime, my lord, only, proceeding may be stayed, my lord, thereafter, my matter will be hard, my, finally, my.
not,
Yes,
Yes,
then my lord, lordship,
Yes.
then lordship may,
Only to ensure,
yes,
only to ensure that service is not,
Lordship,
yes, my lord,
is there from the.
yes, my lord,
Basic, not a law,
yes, Lordship,
and get the
service,
delineation of the law, that's what to
yes, my lord.
then it can be disposed of.
yes,
That is what I propose.
Yes, my lord.
yes,
Saying is one thing, and disposal is one, disposal is forever.
My lord, date may fix for disposal, my lord, till that, my lord, proceeding will state, my lord. Till
We
date.
don't have, vacancy.
yes, Lordship,
Wait,
We don't have vacancy.
Yes.
And the other
Lordship, Lordship,
thereafter we are
24th, my lord. Yes, I am here.
vacancy. Well, that's first. That's first. Was saying, we are contracting customer number 2
Yes, my lord, responded to my lord, FIR file. It was my lord,
by
sir.
registered for 130,000. Mr. Mary can come. Something like that. It's verified. Part of the. As here the 30 for the
Still, my lord,
hotel.
no, track report, my lord.
Right. Of house. In the. Yes. For a. For exciting. On.
24.
24, ma'am.
Lordship.
The pay for. It on the. Name. Is it okay?
Yes.
Lordship.
Notice this, sir, over the appeal.
Highly
August,
appeal.
Lordship.
Go to Mataji.
Highly.
Lordship.
May it please your lordship. Well, the petitioner before your lordship is that is working in a as a contextual employee, my lord, in the establishment of additional district judge Abhaypuri under the Bongaigaon district. Now he's working there since 2015 and in a fixed pay of rupees 9,000. Of late, my lord, in the month of September 2023, there is an advertisement issued by the Bongaigaon district judiciary for filling up of 2 posts of my lord, peon, grade 4. So that advertisement is at page 23. My lord. And the advertisement says, my lord, requisite qualification. Has your lordship got it? My lord? Class 8 passed, HSSLC passed or above shall be ineligible. So there is a barrier, the creation of a class that I cannot pass the SSLC examination. That becomes the obstruction for me, my lord, to my humble understanding. And the thing is that I am working there in a contractual stance. I understand. Yes,
There you have divided.
I am debarred now. I am debarred now because of this clause. Now, my lord, not only this, that it is creating a separate class by putting this clause. One more thing that I would like to, I am continuing in contractual, but I am debarred from taking participation, debarred from participating in the selection process. That is to be started from 22nd of April. My application is rejected. Now, my lord, I would like to show to a chart, my lord, that your lordship can, if lordship can come to page 10, my lord. I have annexed all the documents, but from the table, lordship it will be easy to understand, my lord. Page 10, paragraph 8. These are the advertisements issued by various district establishments of the state of Assam under the Guwahati High Court, where grade 4 employees' qualifications are being consistently given as various things. If lordship can see MSc Tribunal Borpeta, 8 standard passed. CGM Baksa, class 8 passed. CGM Gulaghat, class 8 passed. District 10, class 8 passed but have not passed graduation. There are one more like this. District 10 Session Judge Morigaon, Then Milord, Sijam Hailakandi, minimum class 8 passed and maximum class 12 passed. Maximum class 12, 8 passed and maximum class 12 passed. Minimum 8 passed standard. They're all inconsistent application of qualifications, Milord. If they're under the same judicial establishment, Milord, under the same state, Milord, if this inconsistencies prevails, then
Now, inconsistencies prevail at the time of appointment also.
pardon me.
That was regarding, is regarding advertising.
Yes, Milord.
Some inconsistencies that are.
My respectful submission is, Milord, that this is not uniform in within the state.
That you have said regarding the advertising,
Yes,
right?
right.
The qualification modified or indicated is not consistent.
Yes, not uniform, all,
The same consistency. Consistency. Were there at the time of appointment as well.
in which case, Milord?
On-
These are the advertisement, next to is
These are
advertisement.
advertised.
These are all advertisement.
These are advertised. Initiation the process of election and appointment,
Yes, yes,
right?
right.
What terminated ultimately this process. All these processes that culminated includes election and appointments of 1 or 2%, whatever.
Yes, yes. In those cases,
There, 80%. The qualification above has clearly was appointed in any of the form,
no, that I do not know.
because
Fine.
advertising is part of,
Selection process, yes.
but ultimately, the appointment, election and appointment will be made as part of statutory rules,
My lord,
right?
my lord.
You consulted the statutory rules,
No, but there is no such statutory
it is there.
ministerial rules, Milord.
It is there. If you go to this big volume of rules, the High Court rules,
My lord, I have, yes, it's there in the rules, rule 6D, my lord. My lord, I have given the notification as well as the,
typically like that. What?
My lord,
See, is that ultimately the appointment has to be in accordance with the rules, and advertisement cannot go beyond the statutory rules.
my lord.
That is why I have indicated to you whether from this table any of the appointments,
That information I do not have. But the thing is that if there is
you
a,
continue with your contingency appointment, but I don't think.
my lord, my respectful submission, that if lordship, for my satisfaction, if lordship give me 2 minutes time, my lord. Suppose that there is a notification saying that the grade 4 employees shall not pass the passing day. In my respectful submission, by doing that, High Court rules or High Court has created a separate class amongst the homogeneous.
I was also of the view. I
One,
was.
I understand. But kindly
Now
see,
presently, primarily, I am not of the same view.
if just I am applying my mind or just I'm
I say that like Mr. Samoa, I was also of the view.
because if lordship says that if I or if in public employment, if you fix that upper limit of the qualification, now are we not creating a lower class in?
To do, Mr. Samoa, that if that this kind of issues have been settled by the Supreme Court of
My
India.
lord, I understand lordship will see the chief manager of
Because
Punjab
I-
National Bank. Punjab
yes.
National Bank.
And
No, my lord,
these are
kindly see.
statutory rules. You have to challenge the rules. Then it is the province of the division bench.
My lord will see this judgment once just a look, my lord.
No, these are because mandamus cannot be issued. That is settled by a single judge to do something against the statutory rules. And in the High Court rules, it is specifically prescribed that for grade 4 post, any person having qualification above higher secondary will not be eligible. So this court's power is limited unless you challenge the virus of this act. Am I clear?
My lord, I understand.
And that is not within the province of this court.
But
It has to
we-
be before,
this court means the single judge, my lord.
yes, province of this court. It has to be before somewhere else.
My lord.
Am I clear?
Yes, I understood, my lord. If I take your lordship,
Yes, welcome.
that judgment, my
Let
lord.
us. Please, I can.
2002 SCC 606. 2000, volume 2 SCC 606. Lordship, you can kindly come to page 610. 610, small d at the top, 0. Application of those candidates possessing minimum educational qualification of passing 4th vernacular standard and are educated up to passing 7th standard only should be considered for the interview to the post of peon, and those who have studied above 7th vernacular standard may not take proper interest in the work of the peons and therefore should not be called for interview. It is the 4th criteria which is under challenge as being arbitrary. Under the rules for the post of a peon, educational qualification prescribed is not lower than a pass, lower than,
My question is now, before going further, whether it was part of the rule
well,
in this case.
yes, it is a part, it is a rule.
Where
That
is
rule was under the challenge. If lordship look into the paragraph 6, my lord, it is the 4th criteria which is under challenge as being arbitrary. Under the rules for the post of a peon, educational qualification prescribed is not lower than a pass in examination of standard 4th in the regional language. Out of the applications received, the number of applicants falling in the category of having passed 4th to 7th standards was 1340. The appellants did not fall in that category as they were having higher educational qualification. Out of 1340 applications who fell in the category of those who passed 4th standard up to 7th standard, only 384 candidates were found to be eligible, satisfying all the full criteria.
It's not part of the rule. That was not part of the rule. If you read paragraph 5 from the very beginning,
My lord,
paragraph 5, very beginning, you read only 5D.
yes, my lord. There was,
There were 66 posts of peons in the district and session judge Nagpur.
yes,
On advertisement being issued for filling up this post, as many as 14,965 applications were received. The advisory committee constituted under the rules laid down 4 criteria. The advisory committee had laid down the criteria.
if I understand now, my lord, the lordship will.
Have
if
you
read-
understood the distinction?
Yes, yes. This was not part of the rules. Now,
Had it not been in the rules and Mr. Das as a session judge has laid down the criteria, it could have been within the province of this court. When the matter is related to a prescribed statutory rules, where this upper qualification is made limited, then it will be very difficult for me to
go into.
permit you to and to allow you to participate. That is what the difficulty is,
Mal-
right? Ankit Kumar Das as well as this one. This one is by the advisory committee, not by.
But the
This is
genesis of this, why I'm showing,
Rule was only that prescribing passing the examination of standard 4 in the regional language as the minimum qualification. Nothing higher was prescribed, nothing lower was prescribed regarding, say, a graduate was not.
why I'm showing this judgment, my lord. If lordship goes to paragraph 18,
Okay.
20 and 21, the genesis of the findings of the Supreme Court in this particular case, why a higher qualification should not be a bar. That genesis, that argument is given in paragraph 18 Reasoning is given paragraph 18, 20, and 21, my lord.
That is why I have said at the very beginning, I was also of the view. I was also of the view.
My lord.
But question is, we cannot issue mandamus against statutory prescript. I have indicated to you already.
My lord, I understand, my lord.
We can issue notice at this stage. You continue
My lord.
your job.
My lord,
But
may
if you
indicate
say-
one line to that effect, my lord. That I shall not be thrown out from my contingency work, my lord.
See, how can I? Did not observe anything on your contingency.
My lord.
Third, Mr. H. Chamua, Director of Board of Education. Yes, Mr. Das, anything to say?
Look, so far as the judgment relied on by my senior friend, para 21, my lord, makes a distinction that the judgment is in the particular peculiar facts of the case. Lordship is
Every decision is a decision
Peculiar
of
of-
its own factors
and thereafter
circumstances.
Anit Kumar Das.
Slight distinction in facts makes
Yes.
a whole lot of difference.
Yes,
That's
then
what I like.
Anit Kumar Das and Jarur Ahmed Rathar is also there after that, which consider this aspect of the matter by the Honorable Appeals Court.
My lord, in Anit Kumar Das also, for just academic purpose, lordship issuing notice, I am not against it. my lord. In Anit Kumar Das also, it is said by the Supreme Court that it is right, it is true that the employer has the right to set its own criteria for employment, but that cannot be arbitrary. There must be some reasonable, the classification must be reasonable. It should have that intelligible differentia to establish this nexus of the object, my lord.
So to test it under Article 14 or 16, you have to lay down the challenge on that.
If lordship issues notice, my lord, I may prefer a amendment, my lord, in my writ petition.
And Mr. H.K. Das, anybody state?
State none, my lord.
Standing also GHC for that is point number
2, 3, 4.
3 and 4. The petition is continuing, has been serving in the establishment of the point number 3, 4,
Four, my lord.
as a peon within bracket contingency since the year 2015. So, has been serving continuously. Huh? Yeah. When an advertisement for filling up 2 vacancies in the post of peon within bracket status permanent. Status is permanent. Bracket. On 19/9/2023 by the respondent number 4, comma, the petitioner submitted his candidature. Also. But in the provisionally, in the list of provisionally shortlisted candidates prepared for furthering the selection process, comma, the name of the petitioner has not figured. Name of the petitioner has figured as overqualified candidate, right?
Yes, sir.
Again, Kulja,
Yes, Kogan Kulta.
overqualified candidate, full stop. The grievance of the petitioner is that petitioner has the minimum academic qualification of class Roman 8 pass mentioned in the advertisement. But he has been purportedly restrained from participating. He has been restrained from participating in the selection process, purportedly on the ground, purportedly in view of a clause incorporated in the advertisement to the effect that HSSLC passed or above. Candidates having qualification of HSSLC pass or above shall not be eligible. Mr. Tomo Alanidi. Counsel for the petitioner has submitted that such incorporation of upper qualification is arbitrary and illegal. On the touchstone of Article 14 and Article 16 of the Constitution. On the other hand, Mr. Trask and Planning Council has submitted that such upper qualification has been prescribed in the Guwahati High Court rules, 1967 as amended. And as such, the advertisement is advertisement dated 19/9/2023 is in conformity with the statutory rules. So issue notice returnable on 20/0. As Mr. Das has appeared in expected on behalf of the respondent number 224. Issuance of formal notice to the state respondents. Stand dispensed with. However, Mr. Tomal and for the petition shall supply
Except,
the number of extra copies of the petition and will be connected to Mr. Das within 3 working days from today. Mr. Tomal and for the petitioner will also stamp a copy of the written petition along with an access to the senior government advocate. Some for the purpose of service of notice upon the respondent number 1 within 3 working days.
but the only prayer,
The prayer for
No.
interim relief.
my lord, if lordship, please, my lord. Because the interview is going to be held on 22nd. If the results are declared, there will be a third party right created. So if lordship says in this order that any appointment shall be subject to the outcome of this writ petition. I'm not
That
asking,
can be said.
Yeah.
That can be said.
I would issue notice of report the matter of record by the the any appointment, it is or however object that any appointment made pursuant to the selection process initiated by the advertisement dated 19/9/2023 shall be subject to the outcome of the.
This is- I'm okay. I'm okay.
Absolutely. Leave your place. No, that's fine. Correct.
We don't-
No third party right created.
Take us.
Absolutely correct.
Obliged.
In this case, this is a case where they have assailed finding of a trial court order in a DV case, my lord, where maintenance award of rupees 5,000 was awarded. Subsequently, they have preferred an appeal, which was dismissed. So both of them have been issued before this honorable court. Now the record of the appellate court has come, but the record of, as far as I've seen, my lord,
Okay,
trial court has not come.
I think trial court will be.
Record will be required. Evidence is there, my lord.
What is the trial court case?
Trial
DP
court.
case number 145.
145.
Yes, my lord.
Heard Mr. Ziuddin. learned counsel for the petition and Mr.
S. Nawaz.
S. Nawaz, learned counsel for the respondent. Full stop. The learned counsel for the parties have submitted that the petitioners have challenged the concurrent findings of the learned trial court and the learned appellate court. Full stop. The learned trial court of the originally come on. The no, before the appellate court, comma, an order dated 3/1/2020 passed by the Court of Learned Judicial Magistrate First Class Ojai in DB case number 145 of 2016 was challenged. Full stop. Was challenged in criminal appeal 03 of 2020. Full stop. The appellate court of Learned Session Judge Ojai by a judgment and order dated 26/8/2022 has dismissed the criminal appeal number 03 of 2020. Full stop. By order dated 5/12/2022. Comma, scan copies of the records were called for. Full stop. The learned counsel for the parties have submitted that pursuant to the order dated 5/12/2022, comma, the scan copies of the records of criminal appeal number 03
Yes.
of 2020 have only been received. Full stop. And the scan copies of the record of DV case number 145 2016 have not been received. Full stop. The registry to send a requisition for the scanned copies of the case records of DV case number 145 2016. 4 weeks,
My lord, I pray for early because my lord, the respondent is,
give a fixed date,
yes, my lord.
2 courts concurrent finding, how much?
My lord, there are
5,000 is
cases- no,
given.
There are two cases, my lord. In one case, I am paying 7,000. Another case, I am paying 5,000. 12,000 I am paying regularly, my lord. And there is
Not
no.
my, not regular, my lord, as said by,
Total
him. That's why my lord, I am
We'll
concerned.
take care of that.
Not any convenient day.
Okay, after 3 weeks.
3 weeks.
Most of
Deeply obliged, my lord.
There's a iron lordship.
Hmm.
Perhaps the council is absent.
Okay.
Next,
Time to file objection.
yes, Doctor.
Okay. The learned counsel for the applicant appellant is found absent to the on call. MSSA Coral and additional public prosecutor for the respondent state of Assam has submitted that the objection to the application under section 389 within bracket 1 CRPC will be filed within 2 weeks' time.
Lordship.
First of, in view of absence of the learned counsel for the applicant appellant, release the case after 2 weeks.
Lordship. Obliged.